This is 19 SB 15 Tim Vaughn versus Kirk Blackman. Is anybody here on that case? Okay. See you, Mr. Webb. Is Kirk Blackman present?
He is not, Your Honor. He retained me late yesterday.
Okay.
And I've got about 6 emails, one of them where he's saying he's had medical issues.
All right, let's do this. I'm gonna let y'all go back here to this room. I know what your announcement is on your other case. You got a witness for this, a witness availability issue. Yeah, so I've got that. So y'all go back into the jury room. Mr. Webb, you come on through. And Mr. Harding, you are an amazing and adaptable and agile attorney, so I'm gonna assume you're ready.
I am.
Okay, great. So, all right, Mr. Webb, y'all go talk, see if you can figure out a solution to this, but otherwise, we are having the hearing today. Okay, next case on the calendar, 20 SB 45 Murphy versus RMA.
Good morning, Your Honor.
Good morning. All right. Anybody else here? All right.
Well, Your Honor.
Okay.
I believe we would want it taken down, Your Honor.
Great.
We'll share the cost. I would expect the plaintiff's side, and it's a little difficult to anticipate, but I would expect at least 30, possibly 45 minutes.
Okay.
Maybe longer.
We're thinking about the same, Your Honor.
All right. Well, I already had at least an hour in my head for y'all, so we're on the same page. So,
Thank you.
all right. Thanks, y'all. Y'all grab a seat. All right. 20 SB 302 Bennett versus Evans. Anybody here on that one? I think they're under control. I think they're good. Okay. I was not expecting anybody from that case. All right. Well, I'm actually going to say off. All right, 21 SB 376 Dukes versus Walmart.
Jenny Rogers.
Good morning, Ms. Rogers. All right, who's here for the plaintiff?
Kimberly Mowbray and Terrence Mount.
All right, got both y'all. Do y'all want this taken down?
I do, Your Honor. Do you all want to split?
Want to split? Okay, take down the split. And how long do y'all think y'all's plaintiff side would take?
Your Honor, we resolved quite a number of the issues
Yes.
this morning.
Thank you for that, by the way.
Yes, sir. For my opening and rebuttal, maybe 10 to 15 minutes, just sort of depending, but I think we might do it even less.
Okay. How about you all?
15, 20.
All right, that's fine. I'm gonna put y'all down for 30 minutes. Thank y'all for that. All right, Mr. Harding's bench trial, Mr. Broder, we're looking for him later. Okay, we're gonna handle that one. All right, another bench trial, 22 SB 305 Powell versus Peavy.
Peavy.
You're Miss Peavy? Is Wayne Powell present? Wayne Powell? All right, I'm gonna invoke the 15-minute rule, so have a seat for 5 more minutes and then I'll call you right back.
Yes, sir.
I also need to make certain there's nobody virtual, so. No, I just being very careful. I may have to reboot my system. I show 22 SV 393 Lakeview Marina versus Miller as dismissed. Is anybody here on that case?
Yeah.
Okay. Are you Mr. Miller?
Yes, sir, I am.
Mr. Miller, let me make certain I've got that announcement correct. You may be free to go.
pushing instead of pulling when there are procedures in place saying that there are good safety reasons for why you should pull it, and not walking around to make sure her path was clear is, that makes it unsafe, and that's a question for the jury. But the fact that he didn't know that when she testified that she always used it in this manner, and it's our contention that using it in this manner in contradiction to the policies put in place for people's safety in itself is unsafe, that shows, at least as a question for the jury, and creates a question of fact that Walmart did not properly supervise her. Similarly, creates a question of fact regarding negligent retention. If their employee is constantly using the OGP unit in what we consider to be an unsafe manner and in contradiction to their requirements and their policies, and they don't counsel her, they don't retrain her, and the record is clear about that, and they retain her, and yes, the counseling and reprimands that she had in the file were about coming in late and that sort of thing, but coming in late and then having to hurry to pick up the slack on her work could very well, a jury could very well infer that she is then hurrying and not being as careful in using those OGP units as she should. We believe there's a question of fact on negligent retention for that reason as well. And then the entrustment, that yes, it's usually dealing with motor vehicles, but it's our position that this OGP unit, because it can and absolutely did create a hazard to the customers in the store when used the way that this employee consistently used it, that Walmart had a duty to ensure that she didn't use it in that way, and had every reason to know that she did for the reasons already discussed. And when they failed to correct her improper use of what was ultimately a dangerous piece of equipment, they can be held liable for negligent entrustment as well. And there's a jury question on that. At the end of the day,
Let me ask one question. This is before you pivot to your next point. And Ms. Rogers may have to answer this one. Y'all both have said that this was a new thing. So what does new mean to me? Is this like the second day this program had been rolled out, or had this been like a year and that being new? A new just doesn't give me a concrete, and it's probably in there and I missed it. So does anybody have? Whoever has that answer can give it to me.
So I'm going to let her give it as long as it is, but I was a Walmart shopper, so I've seen it for. Obviously, it's online shopping. So as new as online shopping is, they had to have a way of doing that, right? You're not going to go to the shelf and pick up one thing and take it, and then go to the. No, they've been using this type of thing for a minute.
Because I tried it to COVID, but I'm looking for something concrete. So.
Your Honor, I think if you look at the deposition, I didn't actually cite it as just because it wasn't an issue, but if you look in the deposition of her testimony about her training, I think when she was talking about situational, and that may be the key word to use to go through that deposition, situational awareness, because that's when the people came down to train. I believe that the OGP program had been in place for several months, but that's just my vague recollection on that. I couldn't cite you.
I don't think either of us are arguing like this was brand new and she didn't have time to get trained or anything like that.
Your Honor, if I may, and I could be wrong on this, we can definitely pin that down. When she started, I believe there is testimony and deposition as to when she started this job. But I thought I saw something about training on this in like June or something of 2020, but definitely during COVID time. So it had to be during COVID, which was the main COVID in 2020. And our incident date is September of 2021.
And correct me if I'm wrong.
So this is not we've been doing this for 2 months. She'd been doing this for over a year.
Okay.
Yeah, and that's what I was going to say. I think your main point was this isn't something new and novel, like nobody knew how to do it or what have you. No, this is something that she had an opportunity to be trained on. And I think one of the situations that opposing counsel is saying is that there was no foreseeability, as intimated by Attorney Mowbray. She had ample opportunity, or they had ample opportunity to see that their training of her pushing the cart formed a dangerous situation, particularly when loaded down as it was in this particular situation. And so that goes to negligent training when it comes to entrustment. As opposing counsel intimated, it is similar to a car. If you know a driver endangers the public by driving a car in an unprofessional or unsafe way, and you continue to let them use it, it's the exact same thing as we have here. They entrusted her with this dangerous cart by pushing it. When it was overloaded above her head, she couldn't see it, and that's exactly what you would expect to happen, where you run over a patron is exactly what happened. So I think entrustment and training are definitely a jury question here.
All right, thank you, Mr. Madden. Thank you, Ms. Rogers. Thank you, Ms. Rogers, for your help, and Ms. Mallory, the floor is yours.
Thank you. I think I'm probably mostly done with that. I just, to conclude, obviously, Your Honor has been doing this long enough, and we all have been doing it at this long enough, despite our young appearance for everyone on the bench and at council table on this one. But Your Honor knows. Summary judgment on in general, which is not the case here, but on any claim is only appropriate when there is no evidence in the record to support the plaintiff's claim, and there, to the extent there are, questions of fact, there is no genuine issue on a material fact, and it's clear that as a matter of law, the plaintiff could not possibly present evidence to a jury that would support their claim, and that is simply not the case here. Everything's kind of intertwined with the negligence, the actions of Ms. Amy on this particular day, and in this case, importantly, her actions on this day were consistent with her pattern and practice of how she did her job using this OGP unit, and how she had done her job for, as we've established, over a year, and using this unit that could and did cause injury. And to the very important point, and as I wanted to kind of wrap up, is because this is pervasive throughout all of it, with the negligent, training and supervision claims. One of the overriding themes in those is the foreseeability and the knowledge that this particular behavior on the part of the employee, or the particular, training issue, whatever, is going to cause this kind of harm. There is no question in this case, and it doesn't take a rocket scientist, and it doesn't take an expert to know that if you're pushing something that's loaded down with stuff, and you don't make sure that your path is clear, you could hit somebody. And that is exactly what happened here. There is no question, and this is, for another day, but there is no question that if Ms. Amy had only looked around at the front of her cart, that she would have seen the plaintiff. There's no question. She didn't do it.
Okay.
And that's why we're here. And those are questions on that for the jury. Thank you, Your Honor.
All right, thank you very much, Ms. Rogers. All right, Ms. Rogers.
Just briefly, Your Honor.
Sure.
As far as the premises liability argument, please just look at Lippman. I think Lippman's real clear. The claims are mutually exclusive. You've either got premises or you have active negligence. If you have an active negligence case, you don't go under the statute. But I leave it to the court. That case has been around. There's a lot of case law after it, and there is certainly no case law that I know that says you can do both at the same time. It's a condition of the premises. Your Honor, we're going back and forth about negligent, the negligent issues. We're not here today to argue about Ms. Amy's negligence in hitting somebody. And a good bit of plaintiff's argument has been about that. What we're here about today is, did she have a tendency to hit people? And did my client know about it? Now, it's clear the evidence shows that she'd never hit anyone before, so there was no tendency to hit people. She'd never been written up about it. The only two things she got written up about, she apparently corrected her behavior on, but they had nothing to do with the operation of a cart. What the plaintiff is really trying to argue is that she has been pulling a cart for a year, and that is a tendency to, and perhaps to rush, but there's no evidence that she was anything other than a good employee. And if you look at one of the disciplinary actions, it does say in 2020 she was a very productive employee. The issue is whether or not we're looking at the tendencies is to hit someone or the tendency to push a cart rather than pull it. And Your Honor, the issue before this court is whether you can make those several steps, that pushing is going to cause an accident, which is going to cause you to push a cart into somebody. That's pretty tenuous, Your Honor. If she had been pushing and hit someone, that would be evidence. And if we'd written her up, we'd certainly be evidence of knowing it. But quite frankly, as far as this negligent claim, it really doesn't support it. As far as training goes, their own brief supports the fact that we had a great training policy. They've got all our policies and procedures. Ms. Amy knew them. She admitted she knew them, and she admitted that she knew the difference between them. So the question is, under supervision, should they have seen Ms. Amy pulling versus pushing? If that's what we're going to go with, is pushing is a propensity. And Your Honor, there's no evidence that, other than her statement she pushed, there's no evidence that Walmart knew she was going to push or knew that pushing would cause this accident. So it really does get down to, what do you consider the propensities that my client has to look for? Now, as far as reckless entrustment, in car cases where you're arguing that somebody has recklessly entrusted it, or has entrusted a vehicle to someone who's a reckless driver, the evidence to establish recklessness is usually they've gotten a ticket or they've seen somebody drive speeding, or recklessly. There's got to be something there, a DUI. Those are the kinds of situations where you deal with negligent entrustment of a vehicle. Likewise, if you're going to look at this cart, even if you assume, a non-motorized cart is a dangerous object, there's got to be something, either written up. If we'd written her up for using the cart that way, I could say, yeah, I could understand that. But never written up. They could have deposed Mr. Owen, who was the store manager and a defendant in this case, about this issue. They did not. His affidavit stands unchallenged in any way. They could have deposed her manager, who we identified. They did not. And the manager was the manager over OGP. He'd have been the one watching her and supervising her. But they didn't do that. So there's really no evidence, full opportunity to get it. So, Your Honor, we think that the allegations of negligent training are out because it's so clear that we have a great training policy and that she knew about it and was trained on it. They've admitted to that. That the supervision and retention should be out because there's absolutely no evidence that she had any propensity to hit anybody. Thank you.
Okay, thank you. All right, any last argument from either counsel?
Just briefly, Your Honor. When you talk about the foreseeability, she's saying the foreseeability would only have been known.
Like I said, you move where you want to do. You do this where you want to do this.
She's saying the foreseeability would only have been known if she had had wrecks before. That's not true. The foreseeability is about the negligence, about the dangerous situation that was created by her pushing a cart with bins loaded above her head. And this is exactly what it was. The dangerous situation comes when she pushes the cart. Their policies and procedures allow them and tell them to push the cart and make a few exceptions of when it should be pulled. But obviously a dangerous situation, situation was created when you're loading down these carts and somebody's pushing, and as happened in this case, it's above her head. She can't see ahead of her, and exactly what happened was happening all the time from a propensity to do it. They say that they didn't know. Willful ignorance of a dangerous situation cannot be an excuse and allow them to get out of that they were negligently retaining someone who created constantly a different situation. She said she always pushed the cart, which means that she, whether it was loaded high, low, or what have you, she's pushing the cart. So I think that we're talking about, she's saying that it only becomes dangerous when they knew she had hit someone before. No, it becomes dangerous when you're creating a dangerous situation. That also goes to the argument that we're making, that the dangerous situation was what was created and what was maintained, and it doesn't have to be like a static situation on the pole. Finally, entrustment, she says it has to be, I think, DUI or a ticket or something like that. In this particular case, what again we're saying is she created a dangerous situation. If I drive with somebody and I see they constantly speed, I see they constantly take lefts and barely miss getting hit, right? They haven't gotten a ticket, but I understand that that's a dangerous driver. I'm not going to lend that person my car. In this particular case, as was argued earlier, they had a camera system, which they may say is used for theft prevention, but nonetheless, it looks at every aisle, every row in that store. And they constantly had the opportunity to see that by her own testimony, she continuously pushed this cart no matter how high it was stacked or wide it was stacked. And just as in this case, it caused a dangerous situation. And in this case, it caused an incident where my client was in front of her. She ran my client over with the cart and caused injuries. Thank you, Your Honor.
All right, thank you very much. All right, anything else from either side?
I'd just like to mention that the discussion about camera systems at Walmart, there is no evidence in any of the briefs about the camera systems being, they could have asked about it, they could have deposed someone on the issue, Your Honor.
I think that's common knowledge, Your Honor.
I don't think we take judicial knowledge.
I think it's I'm gonna use it as context, so, let's do this. I think it would be very helpful to me, and I've been tracking it, and of course, as y'all been seeing me looking at my screen, I've been tracking your briefs as you've been citing it, highlighting the cases that you specifically pointed me to, and of course, pulled the exhibits up, including the picture of the OGP attached to y'all's response. What I would like from you all, because it would really help me, is a proposed order from each of y'all. And with findings, fact, conclusion, law, breaking down each of these pieces individually. Because obviously we've got 5 different pieces within the negligent hiring that I need to address.
I think we're down to 3.
Entrustment, retention, and supervision.
I think we're down to 3, Your
Oh,
Honor.
we're down to 3?
Yeah, we're down to
Which
3.
2 am I marking out? Because I got confused.
The ones that I think we are continuing on is the entrustment, the training, and the retention.
All right, so I'm marking out supervision.
And supervision, I'm sorry. Yeah, that is 4. That is 4, yes, supervision.
If we change our mind on anything, that means.
Well, that's okay.
We won't be
All right, well, I'm marking hiring off then. So I would like briefs from each of you all on the 4 subparts of that, as well as, of course, the premises liability versus negligence part. And specifically addressing both the question, but the added question, which is, are they mutually exclusive? Because plaintiffs argued here that they are not. Defense has argued that they are. I'm looking at the cases myself, and I would like you all to address that in each of your briefs, obviously, in each of your proposed orders in the opposite directions. I'd like to, and I'm going to look at those again in the meantime. Is 30 days a sufficient amount of time for you all? Okay.
Yes, sir. Thank you.
So today is March 17th, so April 17th, I think is Monday. I think I saw that. Yes, so it's Monday. So Monday, April 17th, if you all will email us in Word form your proposed brief. You're certainly welcome to email them earlier, but just by April 17th. And again, I think I'm very grateful to you all for your communication lines and how well you all have kind of sorted this out and narrowed down these issues. All right, let me check in with Mr. Hope, see if I've missed anything, and then I'll see if y'all have anything else. So, all right, do y'all need anything else from me before we part ways?
Your Honor, I don't want to take any more time today. Let you get to the rest of your day. At some point in time, we'd ask for a conversation, I guess, with the court, 5-10 minutes, because you have several emails on the subject. And this goes back to the deposition of a trial deposition versus a discovery deposition.
Yes.
Where we were back and forth. And
This was
so
that, yes.
if you would lend us, 5-10 minutes of your time on the phone.
I can answer that. I can answer that here. I've been doing my homework on it. The short answer is that we lawyers have created that distinction as custom and practice. I know that now because I'm so used to saying to the attorneys, all right, you get your discovery depositions knocked out, and before trial, you'll go do an evidentiary deposition. But that is a custom and practice that we've created because it serves the court well. But the fact of the matter is that there's no such distinction in the law. Deposition is a deposition is a deposition. And so that was a surprise to me because I was so entrenched in the customs, habits, and patterns of discovery depositions versus evidentiary depositions, and one being a what do you know, and one being we need to ask this question according to the rules of evidence. So that's the answer to the question is I was wrong. When I said there were two different types of depositions, that was a custom that the legal community has created and not a statutory. And so the short answer is that if somebody wants to try to use it or not, or whatever, that's a bridge we'll cross when we get there. So I was very surprised by that answer. But again, my mentor judge said always go back to the statutes. If I had listened to him at that time, I would have done that before I answered y'all's question originally incorrectly. So I gave you all incorrect information the first time, but that is the correct answer to the question.
Thank you, Your Honor.
And my understanding, Your Honor, is that there's nothing to preclude plaintiff's counsel for taking his own deposition for use at trial.
That's correct.
So I took one, but
I
you
still
care.
allow, we didn't change my case management order. I'm still allowing evidentiary depositions that can be taken for the purpose of getting ready for trial because it's still very helpful to me as a trial judge to move cases forward. And so I still have the custom in my case management order. I didn't change anything. It's just not a statutory mandate.
Well, of course, as we're all aware, after an evidentiary deposition, trial deposition, however you like to phrase it, is already taken, there's very little use to go back and have another trial deposition. So yeah, I'm free to do it, but the usage thereof, and when you notice a discovery deposition and take a trial deposition, it becomes a
Sure, I can tell you my only response to that will be this. I would be very unhappy if during the trial, we had to spend a lot of time picking through, I'll say, a discovery deposition for objections and concerns and wording and phrasing, because you all refused to do an evidentiary deposition that was clean and sorted and organized. So that would be, yeah, you have that absolutely right. But if we end up picking through this thing piece by piece by piece during the trial because you all didn't want to put somebody in the seat to clean something up, I would be very displeased by that. So do I have a recourse on that? No. Would I do a recourse on that? No. Would I express my frustration? You betcha. Because that would be a waste of my time and, most importantly, a huge waste of the jury's time. We owe it to them to try clean, efficient trials, and I have this nightmare vision of the logical conclusion of this moment being that from now on, I'm just going to have to take objections as they go for depositions and all that. So I'm sure you all will sort that out. Y'all have great lines of communication. I'm just telling you my fear from the bench of the logical conclusion of this issue that we've been sorting. So does that help you?
Yes, because I assure you, there was a lot of objections, a lot of different things going on in there, so it would need to be cleaned up.
Yeah. So okay. Does that y'all need anything else? Does that answer your question?
Yes.
Okay. All right. Well, thank you. Anything else? All right. Oh yeah, and you all are tentatively set for August, so kind of pencil that in. I intend on really quickly once you all have given me. I'm not going to do my homework, so once you get it, I'm not going to have to study them deeply. I'm going to just figure out where I want, which one I want where. I may mix the two, but just pencil in August for y'all's tentative trial.
And do you have
Early
dates?
or late
Oh,
August?
the official
Just
dates
out of
would be-
vacation.
Yeah, I'm gonna give you
Yes.
official dates. And again, this gives y'all time to come back and say, I have leave or whatnot. This is why we're telling you now, so that we can know. Trial dates in August are, actually, the calendar call is at the end of July. So, July 24th will be calendar call, roll over to the 28th. So that's Monday, Friday. And then the trial week would be the week of August 7th. So look at your calendars, see if you got leave in, communicate with us, let us know. And then we'll go from there.
1 week trial calendar?
The 7th of August.
Yeah,
Oh,
1 week.
1 week, yes, I'm sorry, you asked me how many weeks, the answer is 1 week.
Thank you, sir.
All right, any other questions, Joe?
That's
Okay.
okay.
Thank you, Your Honor.
All right. All right, everybody, let's take a 5-minute break, stretch legs, step to the restroom, we'll come back and, see y'all are finished. So y'all move to the table during break, and we'll talk to y'all. just formally say with Kathy taking this down that this is what we're about to do, and then I'm gonna have you each agree to it. You ready?
Yeah.
All right, so this is 22 SV 305. Wayne Powell is present, and I've been speaking with him, and then Ashley Peavy is present for the defense, and they're each at their proper table. They spoke back in the jury room and have come to an agreement that if Miss Peavy will consent to the clerk paying what is in the registry of the court that she's paid in to Mr. Powell in full, and I guess relinquish possession of the property. And are you currently in the property now?
No, sir.
Great. Then Mr. Powell will receive the property and the $2,710 that's currently in the possession of the clerk, and the case will be dismissed. Did I miss anything in that, Mr. Powell?
No, you didn't, yeah.
Did I miss anything in that, Ms. Peavy?
No, sir.
Okay, then I'm gonna circle back. Mr. Powell, is that an acceptable resolution of this case?
Yes, it is, yeah.
Ms. Peavy, is that acceptable to you?
Yes, sir.
Okay, then I think we have covered everything we need to cover. Mr. Powell, I did ask you for if you had any feedback on your ability to move through our courthouse and courtroom.
Yes.
Do you have any feedback for me before we part ways?
Yes, well, basically, I just had a major surgery on my spinal cord. And, the only thing I seen wrong with it was, you got the handicaps right here. Okay, but I had to go all the way down here and come all the way back. Other
We
than that,
just had that discussion.
yes.
I don't know. I don't know who looked at that and said that was the right call, but,
I put a ramp up,
But-
take some of the steps out, and put
well,
a ramp up there.
okay, so I'm gonna take, let's go over it.
No, we don't.
Okay. All right, well then, no take that.
Yes, sir.
All right, so, all right, so this is 19 SB 215 Tim Vaughn versus Kirk Blackman, Inc., Kirk Blackman. Mr. Webb is here on behalf of the plaintiff, and Mr. Harding is here on behalf of the defense. And is plaintiff ready?
Yes, Your Honor.
Is defense ready?
Yes, sir.
Okay. All right, so Mr. Webb, this is your motion, and so the floor is yours.
Thank you, Judge. Okay,
You
spit.
can move it wherever you want a little bit.
All right. Judge, seems like every time I'm standing in front of you, we talk about how many years it's been. This is not quite as bad as the last one, though. This is a 2019 case. As you're aware, judgments have been entered. It was interrupted first by a bankruptcy that Mr. Blackman dismissed. Looked to me like it was just introduced to delay this trial and perhaps many others. The most recent bankruptcy filing is attached to the motion, and a review of debtors shows numerous contract claims against Mr. Blackman, which makes sense because the court can't take judicial notice of the numerous lawsuits that have been filed against Mr. Blackman for feeding off of the members of this community. We have a judgment. We have sent post-judgment discovery. There are two orders by this court compelling discovery for both of the defendants, one being Kirk Blackman Inc. and one being Kirk Blackman. Now, Mr. Blackman claims that he's no longer operating his business, Georgia Sunroom, but we know from the court's records that even within the last few months, another lawsuit has been filed against Georgia Sunroom, so he's clearly still operating. The bankruptcy filing also shows that he claimed hundreds of thousands of dollars in annual profit in 2021, claiming about $20,000 a month in income. But of course, there's an absolute paucity of discovery responses showing us what this, where this income came from and where it went. The most recent order from the court compelling discovery came down in May of last year, ordered Mr. Blackman to respond to the discovery and pay $1,000. Previous to that, there was an order from June 11th, 2021, ordering the production of discovery and the payment of $694.25. Both of these orders have been ignored, and Mr. Blackman is in contempt of court. He's been in contempt of court for a very long time. We filed a motion on July 5th of last year. And in that motion, I pointed the court to some authority of how this can be addressed. I cite the court to Wyatt Processing LLC v. Bell Irrigation Inc. This is a 2009 case. It's found on page 3 of the brief. So in that case, the court did something that I thought might be a good idea here, which was to assess as sanctions a daily penalty of $200 a day until discovery was responded to. Now, in addition to that, of course, the court has authority to incarcerate Mr. Blackman for his continuous contempt of court and to purge himself of that contempt by responding to the discovery and by paying sanctions awarded against him, as well as the attorney's fees that have already been awarded and the additional attorney's fees and costs that have accrued since filing this motion. Of course, since we're asking for incarceration, we had to serve Mr. Blackman. First, the sheriff's department went out and it was unsuccessful. Then I hired a private process server, Ms. Thrash, and she has filed, we have filed an affidavit from her. She was here last time before it got rescheduled. She did not make it today, but she was told by an associate of Mr. Blackman to leave his property, and that associate had a gun on his hip, so she complied, of course. And then finally, we got Mr. Blackman served, and that was on the 21st of February, and the affidavit of service has been filed into court. So between the sheriff's department and the 2 private process servers, that's $250. My fees from drafting this most recent motion through today, through all of this, is an additional $2,000. The court had already awarded $1,000 in one of these orders and $694.25. And then, of course, my round trip today is $800, and it looks like I'm going to be here for about another $700 worth of my time. So all that together, that just in the fees and expenses of this, just trying to add that 750 to what I already, or 700 to what I already calculated. That comes out to $5,582. Now, additionally, the court has the authority to award contempt funds to the plaintiff for this willful and continuous contempt. I asked the court to award an additional $5,000 for this continuous knowing contempt. I mean, Mr. Blackman has been emailing the court about all this, and he still has failed to respond to the discovery. This has been going on for years, and the repeated lawsuits against Mr. Blackman, the repeated filing of bankruptcy to escape judgment liability, and then the evasiveness, it shows that he's willfully thumbing his nose at the system, and so I do think contempt is appropriate. I also think that incarceration is appropriate to show him the seriousness of this, and that he needs to comply with his duties as a judgment debtor. That total I gave you, Your Honor, that included 7% interest on those 2 awards. That's where it got up to that total, but I rounded down. I ran it off the cents, and the 7% statutory interest on the $1,000 award, that was $52.95, and the 7% interest on this $694.25, that came out to $85.74. And so that's what we're asking the court for. We've cited to authority. I think it's appropriate and called for in this case. Thank you.
Thank you. All right, Mr. Harding.
Thank you, Your Honor. There's no contention by us that he has not obeyed the court orders. We're not here to say that. We think the incarceration isn't necessary. We have a proposal that we put to the court. This $200 a day, my issue with that is I don't think he's had any notice that could possibly happen to him. Or at least I haven't read anything yet where that's been brought up. Not to say it couldn't be a possible sanction. I just think if you're going to sanction somebody, they should know ahead of time, unless it's an attorney, because we know up front that that's something you're looking at as a possible repercussion for your behavior. So our proposition is to enter an order, have the court find him in contempt, enter an order that he would respond to all of the discovery, the post-judgment discovery, within 15 days, and then he would pay half of the amount of the attorney's fees that were awarded, to include the interest. I mean, that's a statutory provision. And then that he would pay the other half of that award on the 30th day after entry. And of course, that there would be a provision in there that simply says if he doesn't follow any one of these provisions, the court, upon notice from Mr. Webb, generally in the form of an affidavit, can issue a pickup order. And that pickup order would order Mr. Blackman to be arrested and incarcerated until he purges himself by completing these acts that the court put in this new order. He has numerous health problems. I don't think incarceration would serve him or the sheriff's office for that matter. He's retained me to help him come here today, formulate his responses into a format and have them served upon the plaintiff, filed with the court. And we'd ask the court to enter an order along those lines. Other lawsuits really have nothing to do with this. This case has a judgment. So this is just a piling on and trying to really collect the judgment through contempt proceedings is what they're doing. And it's a money judgment, and it shouldn't be collected through a contempt proceeding. It should be collected through either a levy or a garnishment as the law requires. Thank you.
Mr. Spalding, he has other open cases. Have you been retained on just this case, or are you on the other cases as well?
Just this case is of right now.
Okay, thank you. I just
Yes.
wanted to clarify that, because he has this case plus 4 open cases. So, all right.
Yeah, well, first as to the notice, the court will see on page 3 of our motion brief that we point to Wyatt Processing, to which I already said to court, and say, and we point out that in that case, the Superior Court found contempt of the order compelling post-judgment discovery and ordered an accounting for missing funds, payment of attorney's fees, and a daily penalty of $200. That was the authority that we cited to when we asked in our relief that the $200 a day penalty per day for failure to cure the contempt be awarded. That's subparagraph E of the motion and the brief. We also asked for the incarceration. So the relief requested today has been served upon Mr. Blackman on July 5th, 2022, as indicated by my certificate of service, which is attached to the motion and brief. Now, with regard to the irrelevance of the other cases, I pointed the court to the 4 additional judgment creditors, or at least contract claim creditors who are listed in bankruptcy, because I was pointing out that he's using numerous methods to evade liability from his multiple business victims. And of course, this is a fraud case. This is a judgment from violation of the Fair Business Practices Act for deceit. This man has been adjudged liable for violating the laws of Georgia through deception upon my client, and now he's been trying to dance around this judgment for years, and of course only once he was finally served with notice of this hearing does he retain a lawyer to try to respond, and he's asking for more time. He has known about this for a very long time. He has been emailing with the court. He's been emailing with my office. He hired this man last night, and I mean, that clearly, counsel's making the best argument he can, and nothing against him, but this is about a predator on this community who's been feeding off of its citizens, taking their money, and putting it who knows where. But my client is entitled to some of that money that's squirreled away somewhere. There's judgment entered, and he needs to tell us where it is. And I don't know what his health situation is. Frankly, I don't believe anything he says. I'm sure there's something going on. I'm sure he didn't just come in here with a walker for no reason. But I mean, these crocodile tears for attempts to get sympathy from the court is completely irrelevant. And he should be put into jail. I wish that the county would throw him in jail. The best I can do is ask him to be held in contempt until he complies with his discovery duties. Thank you.
Mr. Harding, any additional response?
Well, again, I mean, most of this argument is just an emotional argument. There's a judgment. He's already been found liable, Your Honor. It's not a question of liability. I mean, that is what it is. The judgment was had. I don't think he's crying crocodile tears. He's came in here. He's already stipulated that he didn't answer the discovery. He's offered to answer it within 15 days, which isn't all that long. Offered to pay them for their time. Again, I think all this incarceration and the daily fines, it's just an attempt to actually collect the judgment. And there's no evidence he's squirreling away money anywhere. That's just statements they're making without evidence, and that really aren't relevant to this. That's the whole purpose of the discovery, is to answer those questions. Thank you.
All right, thank you, Mr. Harding. All right, Mr. Webb, anything else?
I would just point out, Your Honor, the sworn bankruptcy filings indicate a lot of assets, 200,000 in the year 2021, and much of that was subject to a judgment that had already been entered by this court. Additionally, a claim of 46,000 in assets. So his own sworn statement is that there are substantial assets. That's all I was going to point out. Thank you.
All right. All right, so obviously taking notice of my own docket and what's in it for the history of this case, which I appreciate you all not telling me what's in my docket as we have this hearing, which would have been very tempting to do. The fact is that this is a 2019 case. And that it did move forward. And since this case has moved forward, we've ended up ordering multiple motions to compel, and each of which was frankly unproductive. To my knowledge, is that correct, Mr. Webb?
Yes, Your Honor.
Okay. I also need to just take a moment. So in preparing for this hearing, the idea of locking someone up on a civil case, as you all are well aware, is a very rare bird and a very rare moment. And, I've been on the bench 6 years. I've been an attorney long before that with you all. And before that, I've only locked up one person or ordered one person locked up, and I didn't actually end up locking them up. They ended up resolving their issue before they went to jail. And what I did was I went back through my records to figure out, was this a one-off case or was this a pattern? And here's what I found going back through my own records as the court. So what I did was I pulled everything that had to do with either Kirk Blackman individually, Kirk Blackman Incorporated, or Georgia Sunray. Those are the three entities that are directly attached to Mr. Blackman. And I created this list, which you all are welcome to have a copy of when I'm done. It's the number of cases that I found that are specifically related to Mr. Blackman or one of his businesses in an allegation of fraud, deceit, or a contract violation relating to work on a sunroom that he contracted with and is now an allegation. And here's the cases, starting with the magistrate court. 02-S-535, 03-S-0138, 06-S-0392, 06-S-0577, 07-S-0838, 11-S.1270, 14-S-0283, 15-S-0456, 17-S-0384, 21-S-1320, 21-S-0962, and 22-S-0586. That's in the magistrate court. I then went upstairs to Superior Court, and I found the following cases, which I did my absolute best to confirm that these were not transfers of the magistrate court cases, and to the best of my knowledge, they are not. 98-V-01001, assigned to Judge Hankinson. 06-V-914, assigned to Judge Hankinson. 06-V-1276, assigned to Judge Hankinson. 13-V-1252, assigned to Judge Hankinson. 14-V-1263, assigned to Judge Edwards. 15-V-981, assigned to Judge Ballard. 15-V-1002, assigned to Judge Edwards. This next case is open and pending. 15-V-1484, and it is assigned to Judge Coker. 17-V-1127, assigned to Judge Miller. 18-V-735, assigned to Judge Sams. So 22-V-975, this one is open and assigned to Judge Coker. 22-V-998, assigned to Judge Miller. Those last two cases are open. Then we come over to the criminal side. There was 20-R-398. It was a criminal case, theft by conversion of real estate property improvement funds. It was dismissed. I will note that. It was null prost for the record. but it was something that ties into this whole conversation. And lastly, we end with my duck, state court. Here we go. 06V 498, 17SB 237, 18SB 39, 18SB 40, 18SB 178, this one, 19SB 15, and then 20SB 283. And then there is a brand new open case with a different plaintiff that has not been decided, but is exactly the same set of patterns. I read the complaint. It's 22 SB 401. Mr. Blackman has kept me very busy since I took this bench. I have dealt with numerous of his cases. And frankly, I see a pattern from my own dealings of this. And I think the fact that I just read out 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 32 civil cases in the last 20 years, a little over 20 years, tells me that this is where we're at. Now, that is context. But for this case, purposeful, I have issued numerous rulings of motions to compel. I've tried to get this case moving numerous times. And I'm deeply troubled by Ms. Thrash's affidavit that when she attempted to serve him, that she was ordered by an armed person after speaking with who she believed to be Mr. Blackman, who fit all of his descriptions, but who denied that he was Mr. Blackman at Mr. Blackman's house, at Mr. Blackman's garage, but it was not Mr. Blackman. So if he's got a twin, I'm sorry, that's my bad, I'm jumping to the wrong conclusion. But otherwise, I have a man at his house that looks just like him, that is the right age, that is saying it's not him, and ordering a properly present process server with the threat of a firearm, or at least the implied threat of a firearm. Let me be very careful here. And so I'm telling you these things all as context because I'm simply trying to say any of these in and of themselves are not persuasive to me. But when I take the whole of this picture, which I think is my obligation here, is to say, you know, is this a pattern or is this just a series of miscommunications? I'm going to find that there's a pattern. It's a very clear pattern. And frankly, my pattern is just in this case of itself. But I'm simply acknowledging that when you broaden it out, it absolutely makes it proof, not by preponderance of the evidence, like this is enough for me by any legal appropriate standard. Clear and convincing evidence, proof beyond reasonable doubt, whatever you want to call it. But by preponderance of the evidence, there's gracious plenty here. And I have no hesitation ordering Mr. Blackman to be incarcerated. However, this is a civil contempt, and what my goal here is not a punitive incarceration. I am thrilled beyond belief that Mr. Harding is in this case, and I am very confident in his ability to get this moving forward. And I want to say that out loud, that when Mr. Harding stood up this morning and announced for Mr. Blackman, I was overjoyed because I'm tired of Mr. Blackman emailing me, and I know that Mr. Harding will tell him to stop emailing me, that I am not your person to communicate with about this issue. And so I trust very much that Mr. Webb and Mr. Harding will open lines of communication. But I am very comfortable saying that Mr. Blackman is going to need to go to jail today. So I'm going to order him taken into custody. It's going to be civil contempt. Do you have a proposed order, Mr. Webb?
I can email you one.
Okay, I want it ASAP. But I want it to be very concrete.
Turn around. Stay where you are.
So, Mr. Harding, I'm going to put very concrete, very clear steps.
The other hand.
Because this is going to be something he can do. He's going to be able to purge himself as soon as he gets my checklist done. So this is not locked up forever. This is not a 20-day contempt, direct criminal. But I think that it is well past time for him to feel those bracelets on his arms. I think it's time for him to sit on the other side of a jail cell door for a little while and contemplate the fact that I am finished and utterly out of patience with his actions and continue, every case I have with him goes like this. Mr. Webb's just the first one to make it to me this far, and so he wins the race. So, and I'm just done. And so, Mr. Blackman, I want to make certain you clearly hear me say, because you and I are still going to be doing this on 22 SV 401, that I'm going to go ahead and take judicial notice in 22 SV 401. I don't think that's your case, is it? Okay. That any non-compliance of my order will result in an immediate one of these hearings. Because I'm just kind of tired of having to tell this over and over and over again, that I just want you to do what I want you to do. So, okay, Mr. Webb, I'm going to review all. You're asking for several different monetary penalties. I'm going to ask you to please individualize that. I'm not entirely certain that I'm going to grant all of them as we go. Mr. Harding, I would like you to speak with your client. I would like to know what he does have the ability to purge immediately, or if he could move assets, what he could do to purge otherwise, and also like what exactly y'all need to do to get the items together for Mr. Webb, because I'm looking for, as soon as Mr. Webb says I have everything I need and I've been paid the amounts that are due, that I'll issue a purge. And so let me see if I'm missing a procedural step here. Oh, yeah. All right, so Mr. Webb, you need to get that order to me like within an hour or so, because otherwise I'm gonna have to let him out. Because I'm not gonna draft that order. I've got to hear this next hearing, and then I got to know everything after that, and there's no scenario. But if I don't have it, by about after lunch, they're not gonna be able to book him, and then I'm gonna have to let him be released. So, and I won't hesitate to do that either, Mr. Harding. So I'm sure Mr. Webb will get me this order, but in the case he doesn't, I'll order Mr. Blackman to be released. So
you said by when?
So 1:30, something. I mean, just ASAP, because I've got to have time to review it. I've got to make a couple of decisions, because like I said, I'm a little concerned about this $200 a day. I think the $200 a day would have been if I wasn't incarcerated. So I'm just telling you that I'm kind of framing up that one a little bit. I've locked him up. Frankly, I don't know that I need to do the $200 a day. The $200 a day would have been if I didn't lock him up. So that's just me telling you kind of what I'm thinking and why I want it in Word, but I'm gonna look at that case you sent.
Okay.
And I will certainly consider it. I haven't made a decision. That's why I want it in Word, and I want it broken out.
Yeah.
All right. Mr. Blackman, I hope I've made myself abundantly clear. Mr. Harding, I'm thrilled that you are in this case. I trust that you will work quickly to get your client, to get these things to Mr. Webb so that I can let him out. I don't intend on keeping him one more minute past when I need to. And so, Mr. Blackman, you have a fantastic attorney. You need to do exactly what he tells you to do, exactly when he tells you to do it, because he knows this court really well. He knows what I'm looking for, and he knows what I'm going to need before I'm willing to let you out. But either way, you're going to be there for the weekend, so you might as well get settled in. So, okay. That's it. It's my sincerest hope that I get word Monday that y'all have worked all this out, and then I can let him back out. But otherwise, he will remain incarcerated until I'm satisfied that this is back fully on track. Okay? All right, Mr. Webb, anything else?
Thank you, Judge. I just did Mr. Harding's email so I don't send an ex parte.
Okay, that's fine. Mr. Harding, anything else before we go off?
And your order will contain the purge provisions.
Oh, yes.
Yeah.
So, and so it will say exactly that. So, okay. Anything else, Mr. Harding?
No, sir.
Okay. I'll let Mr. Harding tell you his email address while we're off there. So it's unorthodox in the way Mr. Harding is unorthodox. All right, we're off, Rick. Okay. So let's go on record with 20 SV 45 Murphy versus RMA trailer. I had a moment when I printed this. All right. All right, you didn't want this taken down if I remember correctly?
Yes, Your Honor.
All right, and this is the case, I remember us talking this through last time, correct?
Yes.
Okay. Where we knew there was a drywall expert, we knew we were gonna deal with that, and then there were some other witnesses that came forward kind of late, this is the, okay, so I just wanna make sure that I totally have this straight in my head of where we're at, so. Okay, so the, defense, has filed a dog motion on the sheetrock expert. If I'm correct, what am I missing?
Sorry, Your Honor. There's a sheetrock expert and a roofing
And,
expert.
yes, I have two, so, all right, is that what else are you looking for me to address today?
Our renewed motion for summary judgment.
Yes, got it, so 3 items.
Yes.
Well, there was a motion to strike an affidavit as well.
Oh, that's right.
Got it,
And there is the issue of the 3-day rule.
okay, fill me in on that.
Well, the defense says that the plaintiff's briefs in response to the motion for summary judgment were late.
Oh, okay. All right, that's fine. Let's just argue the case. I'll take that under advisement. We're here. Let's go forward with what we got where we are. All right, so as far as, y'all can address it, I'm just saying let's go forward. So, so with this being, most of this is the defense's, actually most all of it is, so I'll let you all go first. Who would like to, who's gonna speak on y'all's behalf?
We'd likely both, well, I guess it depends on
Great.
what you want to handle
Yep. Who wants
first.
to go first?
We'd prefer to do the motion for summary judgment first, and then
I'm
do Dalbert.
happy to handle this in the way that it flows best for
We
you
have
all.
some exhibits, so I think Matt's gonna be doing most of the talking, and I'm gonna be the Vanna White for the.
Okay, and we have
Just
an
to
easel
help him.
floating around here
I
somewhere.
think it'd be easier if I can just stand up.
That's fine, I just want to say out loud that we do have an
Don't you
easel,
think?
so. Okay, well then,
Yeah.
I'm ready if y'all are.
Your Honor, is it okay if we stay?
Oh, yes, yes, but there's no jury present, y'all feel free to stay or move as you go.
We certainly appreciate it. I'm Matt Dowling, I represent the senior appraiser, the defendants in this action. Your Honor's well versed in this case at this point. We've seen more than enough of us, I suspect. Like
Your
to
Honor,
try.
I hate to interrupt, but could I ask Matt to speak into the mic?
Oh, that mic only works if you get really close to it, so just grab it and pull it close. And,
Does that matter?
yeah, just make sure to lean into it. It gets louder the closer you get. It's,
Okay,
it's
fair
a,
enough.
it's that kind of mic.
Fair enough. Your Honor, at the outset, although there is a lot of mud in the water in this case, it is actually very straightforward. And the application of the undisputed facts to the black letter law leads inexorably to the conclusion that this is a proper case for summary judgment. There's no dispute at this point between the parties that this matter is traveling under OCGA 44-717, the out of possession landlord statute. And pertinently, that provides that having fully parted with possession, the landlord is responsible for damages arising from defective construction or damages arising from the failure to keep the premises in repair. In the Plaintiff's brief, plaintiff concedes that this is not an effective construction case. We agree. So all we're looking at is the issue to repair. Liability can only attach to an out-of-possession landlord for failure to repair an alleged defect of which she had knowledge. It's as simple and ordinary as that. Here, the undisputed evidence shows that the only notice that Defendant Prather and Defendant RMA received was a complaint about a hole in the kitchen ceiling. That's it. Nothing about a leak in the living room, nothing about a crack or a bubble or a hole or any other condition whatsoever in the living room where the incident allegedly happened. A complaint about a hole in the kitchen ceiling. That's it. And because of that, there was no duty for RMA or Ms. Prather to repair the living room in the intervening time when this incident happened. Received notice on the 14th, was reported to RMA on the 15th. Michael, the tenant, corresponded with Ms. Prather on Saturday the 16th to say everything was cool at the apartment. No urgency there, no leak, no water, no trouble, nothing. And then Sunday evening, the living room ceiling allegedly collapses and falls on Teresa Murphy. I think at the outset, before we really jump into the law, I'd like to just kind of run through some of the mud and water, some of the inconsistencies that we're dealing with to give you a flavor for the problems that we've been suffering in this case. Were there or were there not dogs at Michael's property? According to Teresa Murphy, she'd been there about twice and he had 2 big pit bulls. Michael says the lease didn't allow pets, and he never had pets at the Fuller property. Tamika Threat said she didn't see any dogs when she was there on the day of the incident, and didn't know that Michael ever had any dogs. How did Ms. Murphy get into the apartment on the day of the incident? She testified that she did not have a key. Michael never locked his front door because his girlfriend didn't have a key either. Michael testified he asked his mother to go get his clothes, and he was out with his girlfriend. His mother came and got his apartment key from her. Tamika Threat testified that Ms. Murphy knocked on the door first, then opened the door using a key that she'd already had. She didn't know how she had or came by the key. Whether or not there was a noise prior to the alleged ceiling collapse. According to Ms. Murphy, she was talking to Tamika Threat about a guy at the church when she heard a noise that sounded like an animal and said, "What is that, Tamika? A squirrel? A bird?" And that was it. Michael has no knowledge, he wasn't there. According to Tamika Threat, she didn't hear anything in the moments before the ceiling collapsed. What did the ceiling look like on the date of the incident? Ms. Murphy testified she didn't notice anything about the ceiling or anything amiss with it at all, and that she didn't pay any attention to it when she first went into the apartment. Michael didn't have anything to say about it. He couldn't remember whether or not he spent the night at the apartment the night before. According to Ms. Threat, she noticed that like half of the ceiling had fell down on the floor and it was still on the floor. And one half of the ceiling was still intact and the other wasn't. She also noted that there was a hole in the ceiling and wet sheetrock had fallen to the floor. How did Michael get notice of this incident? According to plaintiff, Tamika told her that a neighbor called Michael and he arrived as the EMT was leaving with plaintiff in the ambulance. According to Michael, he testified that Tamika called him and told him that his mother was being rushed to the hospital because the ceiling had fallen. According to Ms. Threat, she said she never spoke with Michael via the night on the telephone on the night of the incident. And she testified further that Michael just came out of nowhere and she had no idea how he knew anything had occurred at the apartment. How long were Teresa and Tamika on the premises prior to the ceiling collapse? Plaintiff couldn't recall it. It didn't take long. Michael didn't have any knowledge. Ms. Threat thought that it took about 5 to 10 minutes. whether Ms. Murphy had knowledge of prior ceiling problems in the unit. According to plaintiff, she testified that Michael never told her anything about any issues with his apartment. She did not know anything about any leaks or holes in the ceiling. According to Michael, his mother had been in the house about 5 times, that she knew that there were ongoing ceiling issues. She personally saw the hole in the kitchen ceiling. He also testified that on prior occasions, he'd warned her to be careful, that she knew about a bubble in the living room, and had warned her that it was dark in there and the water accumulated on the floor. He warned her to be careful. According to Ms. 3, during her first visit to the apartment, she asked Michael what had happened to the ceiling. Teresa was standing there, and Michael responded that he didn't know. Ms. 3 also said that she asked Michael if he'd ever called to have anyone fix it, and he said yes. She testified that there was a crack, and it was noticeable, but she didn't notice it right away. Whether Ms. 3 knew Michael's address, plaintiff didn't have anything to say about that. Michael didn't have anything to say about that. Ms. 3 testified that she did not know the address, and that she did not give 911 an address because she didn't know it. 911 recording shows that the first thing Tanika 3 does is ask for an ambulance at 1005 DF4. Whether or not plaintiff lost consciousness. Ms. 3 says she did, but she wasn't sure. But then she did. Plaintiff says she did. According to the EMT report, plaintiff was conscious and alert when they arrived, and she signed the report. Now, obviously, these are all questions of fact and credibility, and we appreciate that. This is more to give the court the flavor for what we're dealing with, and then to show why the undisputed facts, ones that actually matter, tell the story about what happened here, make this case right for summary judgment. So, first off, we have a chronology that we've worked on.
And I can see it, if you want to set it on the ground, I can see it just
Okay,
fine.
perfect.
Yeah, so I was thinking, we'll lean against front of the podium, but if y'all need to be able
Yep.
to see it, that's fine.
No,
So
it's
I
fine.
can pull the podium back. There we go.
Pull it up.
Okay.
May I approach?
I was trying to say that, let's go for it. I was trying to say that you could move the podium behind it.
Oh, that's
since
what I
y'all
was,
are not
I
using
wanted
it.
to move the podium.
Ah, there you go, Tom.
Great, thank you.
May I approach?
You may.
Yeah.
Okay. You see it up here, Mr.
Not now.
You just leave it. There we go.
So Katrina Craven purchased the property August 17th, 2016. It's about 16 months or so before the incident, December 17th, 2017. December 27th, 2016, Michael submits a work order to replace a toilet handle and a brace for the back door. It got taken care of. January 9th, 2017, Michael submits a work order to remediate some mold in the unit. It gets taken care of. May 26, 2017, Michael submits a work order for request to mow the lawn. It gets taken care of. July 13th, 2017, Michael submits another request to mow the lawn. It gets taken care of. In October 2017, Michael testifies. He watches the men on the roof put some water to test whether there is a leak, and that there was no leak. November 2017, Ms. Prather asked that ceiling fans get installed in the 3 units, which got taken care of. On December 14th, RMA served Michael with a dispossessor. That same day, Michael called Katrina to tell her that there was a hole in the kitchen ceiling. That's it, a hole in the kitchen ceiling. The next morning, Katrina called RMA and reported that to the work order hotline, and RMA generated a work order. Saturday, December 16th, day after the work order was submitted, Katrina texts Michael to say, I'm not gonna be able to make it over to the property today. And he responds, okay, cool, no problem. And then on the evening of December 17th, the ceiling allegedly collapses on Ms. Murphy. These are all important because, one, shows that Michael knew how to make work order requests. During the time Katrina Prater purchased the property and the incident, he'd made no less than 5. It's a simple process.
These are in chronological order, so this is first and this is second.
Yeah, that'll work great.
Does that work okay?
And again, this just to show he knew how to make work orders. He could call, request help at any time for any issue he was having on the property, and they got resolved. Next, and to further that, see that Michael knew how to reach out to Katrina if there was work that needed to be done. Easy enough. Going to the issue in October,
These next ones.
we've still never been able to pin down exactly when this happened. But the important thing is, some point in October of 2017, folks from RMA came out to the property to deal with a presumed leak. They applied a tar substance to the roof. Michael was there. They ran water on the roof to see if it continued to leak. According to Michael, it stopped. Problem was fixed in October. There's no more leak. It had been repaired. Fast forward to December 14th. Michael tells Katrina that there's a hole in the kitchen ceiling. That's it. No water, no leak, nothing about the living room. See at the bottom. When you talked to Michael about the hole in the ceiling, did he tell you that there was a water issue? He just stated that there was a hole in the ceiling and sent the picture. All I recall is a hole. So based on what Michael told Katrina, Katrina called RMA, submitted the work order. The owner called today, said that she would like us to go over to this residence and check out a hole in the ceiling that the tenant talked to her about. At some point a few months ago, we patched the sheetrock, but now a hole is evident. Again, a hole in the ceiling in the kitchen. No water, no leak, no crack, no bubble. And then, to top it off, The next day, Saturday, Katrina texts Michael, "I'm not gonna be able to make it by today. I did talk to RMA about the roof problem." Michael responds, "Okay, cool, no problem." The only logical takeaway from that is that this was not an emergency. This was not a pressing issue. This was not something that he was particularly concerned about at all. Had it been pretty much any response other than, "Okay, cool, no problem," would have gotten that across. But as it stands, that's what we have. He was not complaining about an emergency situation. And we know from the other testimony that none of the complaints in that week of December 14th, 2017 were about leaks or water or bubbles in the living room, a hole in the kitchen ceiling. And that's where the court now has the opportunity to grant summary judgment. The duty to repair under the out of possession landlord statute only attaches when the landlord has knowledge of a defect in need of repair. The only knowledge that Katrina Prather and RMA had of a defect was of a hole in the kitchen ceiling. So Michael reported that. Everything else is just mud and water. It's a red herring. Giving plaintiff every benefit of the doubt, he'd say there was a leak at some point in the fall of 2017. He didn't make any complaints about it. And if he did, it was repaired back in October. Fixed. So neither defendant was on notice that there was a problem with a leak in the living room. And certainly hadn't been provided any notice that something could have happened was so severe that the ceiling was going to collapse. What Ms. Prather and RMA were on notice of was a hole in the kitchen ceiling. A couple of the cases that we've cited in the brief are helpful. Bennett, for example, 359 Georgia Ave 804. There's a weakened board at the bottom of the deck, but the tenant never advised the landlord of the problem with the loose board until after the incident. Summary judgment for the defendant. In terms of the duty to repair, steel, I think we cited this one in our reply brief. 222 Georgia Ave 451. Landlord's responsibility to repair a latent defect is not absolute, but is predicated on the landlord's knowledge of the defect and the need for repairs. Katrina and RMA were notified about a hole in the kitchen, not about anything to do with the living room. In Gain, also cited in the reply brief, 287 Georgia Ave 529. Liability can only arise in instances where there is a duty to repair and notice has been given of the defect. The defect here was a hole in the kitchen. That's it. Two witnesses came forward independently without solicitation from anyone on the defense side. Xavius Murphy, one of plaintiff's sons, and Shrika Ellaby, her former partner. Both of those witnesses just walked into the RMA offices and told them that Ms. Murphy had made up the whole incident, had staged it. This is an affidavit from Casabian's murder. Approach. Yeah. These are exhibits. Turn to the second page. Notice that he's aware that his mother's brought a lawsuit claiming she was injured when a ceiling tile fell on her when she was visiting his brother, Michael Murphy, who was riding DF4 property. The incident reportedly happened on December 17th, 2017. Paragraph 6. Approximately 1 week after the supposed incident, I was visiting my brother and mother at the property, 1005 DF4 Drive in Griffin, Georgia, property managed by RMA. During that visit, both my mother and brother told me that my mother had staged the accident to make it appear as if the ceiling fell on her. My mother and brother told me the ceiling did not in fact fall, but that my mother and or brother took a broom handle and hit the ceiling so that it collapsed. That's the only thing that makes any sense here. And again, while we appreciate that the testimonial inconsistencies that we highlighted at the outset, as well as the substance of the affidavit, are questions of fact and credibility. The undisputed facts show that there was no notice to RMA or Ms. Prather of any defect in the living room in the time prior to this incident. They got notice of a hole in the kitchen ceiling. And the opportunity is now present for the court to dismiss this case. Stop this frivolous action. The law is very clear. There was no notice. In the situation of an out-of-possession landlord, there has to be notice of the defect to trigger the duty to repair. Neither Ms. Prather nor RMA received any notice of the defect in the living room. It's as simple and ordinary as that.
All right, thank you, Mr. Dowling. Just to say it out loud, it's 11:36. Got a hard stop at 11:45 to resume at 1:30. So I just want to make certain I've said that again. I just want to make certain. I
Oh,
don't
we
have to
can come back.
Yeah, yeah. No, it's a lunch event that's in the courtroom and we need 15 minutes to get it set up. You can leave all of your stuff because we can put it, over here. It's just an event where it's an unveiling of that thing. And then we're having, very pertinent to you all, we have a very distinguished speaker, on the admissibility of experts. And you're welcome to stay and, be a part of it, so. But anyway, I just want to say out loud, that's where we're at. So just be thinking about that I've got about 11:45 hard stop, so. Anything else on that one, Mr. Dowling?
No, only if you had any questions, I'd be happy to answer them.
No, I'm tracking you all. Obviously, I already heard this case on previous issues that were related and read all your briefs, and of course, I already looked at Casabian Murphy's because it was attached to the exhibits as Exhibit P. And so I appreciate the copy, but I just want to let you know I have it when you reference it. Mr. Edwards, I don't want to get you started and then stop you.
That would be my preference.
Yeah, okay. Well, let's do this. Why don't we this is a good stopping point. It's a few minutes early, but we're all right. I want to give you all a minute. Why don't we take, I don't want you to feel like you have to take your stuff out, so why don't we'll go off record, we'll take a minute. We can put your exhibits, you're welcome to put them one of a couple of places. You're welcome to, there's a little pass-through room right here, and this is the secure area. You're welcome to actually put them back in one of the two jury rooms. We're not going to be doing much back there, other than folks may step to the restroom back there. And I just want to make certain that you don't feel like you have to pack all of your stuff up and take it. So y'all can, there's two jury rooms back there, so you can each pick a jury room and claim it as your own. Yeah, let's just do that, and I'll just tell everybody that y'all's stuff is back there and do the And let's go off record, and we will resume this at 1:30 this afternoon. Again, you're welcome to stay. Like I said, this is very pertinent to what we're doing here today.
Who's the speaker?
But at the same time, so there you go. So the author of Admissibility of Expert Testimony in Georgia by Thomson Reuters. So thanks to Mr. Hope for setting her up. All right.
Mind if I swear her in as a witness?
That's exactly right. Okay, we're off record adjourned.
Mayor, on this trip,